All right. So we're just going to be going over a few questions. So feel free to just raise your hand or shout out whatever answer you think um, um, might be. So first question. So a psychologist is treating a client for anxiety and depression. And during therapy, the client reveals that they are struggling with substance use disorder. The psychologist has not been trained to treat substance abuse, but is considering referring the client to a specialist. The client requests that they continue seeing the psychologist despite the lack of expertise. What should the psychologist do? So we have A, continue working with the client and try to address the substance use issue to the best of their ability. B, refer the client to a specialist in substance abuse treatment, but continue therapy to address anxiety and depression. C, explain to the client that they are unable to treat the substance use issue and terminate therapy altogether. Or D, proceed with therapy while incorporating substance use treatment techniques despite the lack of expertise. So, what do people
So,
have?
rule of thumb, what's the best for the client? That might be something to remember when trying to consider these ethical questions. What might be the best for the client? I do not know the answer. Uh, in this, I'm going to guess, but I'm going to let other people guess. But think in terms of what's best for the client. Natalie.
I'm gonna say B, referring them to a specialist in substance abuse treatment, but continuing to address the anxiety and depression just because I'm thinking about our boundaries of competence and within one part for anxiety and depression, the psychologists, if they're able to, continue therapy with that, get to those underlying symptoms. But if one part of it, whether substance use is out of their expertise or like out of their competence, referring out to ensure that they are getting treated for those um, presenting issues is my rationale.
Okay.
Mm-hmm.
Who else?
Anybody else have any thoughts?
Yes, thank you, Sammy. The rule of thumb I use is how could an angry plaintiff's attorney make this look in front of a jury of 12 citizens?
Mm-hmm.
Uh,
Great point.
so the questioning would be, so you don't have expertise in substance abuse treatment, do you, Dr. Venn? And yet you continued to see the person. Well, I continued to see the person because that's what they wanted. You know, one of our guiding principles is self-determination. The client still wants to see the psychologist, so okay, we acquiesce. This is what the client wants. But how do we defend ourselves if we tell the client, I'm referring you, I'm going to give you several names of substance abuse specialists who can treat your substance abuse? And then it's up to the client. If the client says, no, I don't want to go, well, we can't force the client to do anything.
Exactly.
I think C, terminating therapy would be too severe and not in the client's best interests. I agree with Natalie. I like B. And we document in our note, I encourage the client to see a substance abuse specialist, and I gave the client several names and phone numbers, and then it's up to the client what to do with that.
Yep.
Okay.
Well,
It looks
well,
like I was just gonna say it looks like both Natalie and Dr. Ben had similar responses, and
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 I
yes,
agree.
the correct answer is B.
Okay, cool.
And justification, pretty much same thing that was said. They're ethically obligated to provide services within their scope of competence, kind of what Natalie was saying. So for this example, since the psychologist is not trained, it is best to refer the client to a specialist, um, and then continue to treat the client's anxiety and depression.
God, we're smart.
Next,
All right.
all right. So, next question. A psychologist is treating a client who recently disclosed they're experiencing thoughts of harming another person, but insists they do not intend to act on those thoughts. The client requests that the psychologist keep this information confidential. What should the psychologist do? Is it A, respect the client's request for confidentiality and continue therapy without reporting the thoughts of harm? B, discuss the ethical dilemma with the client and strongly encourage them to seek help voluntarily before deciding whether to break confidentiality? C, break confidentiality immediately and report the threat to the appropriate authorities, even though the client insists they don't intend to act on those thoughts? Or D, provide the client with tools to manage their thoughts while making it clear that further discussion of harmful thoughts will result in breaking confidentiality if necessary.
So what are we talking about here, guys, in general?
Suicide risk.
Well, no, he's talking about hurting somebody else.
Yeah, homicidal
Or
intent.
yeah,
So,
homicidal,
Well,
not
we're
suicide.
talking about Tarasoff.
Mhm.
yeah. Um, I know I would rule out C just because there's no there's no identified third party person. So if you break confidentiality and report to authorities, like what are you reporting? Just this client has thoughts of harming someone, but who is this person that they're thinking about? Um,
Mhm.
so that's where my thoughts are. That's why I'd rule out C.
So
Um,
you're saying we apparently do not have an identifiable victim.
yeah,
Mhm.
correct.
Does
So
that change things for you if it said here uh, they disclosed they are experiencing thoughts of harming an identified other person? Does that change things for you?
I'd need like more detail, like who is this person? Not just like an identifiable person, but like if thoughts of harming, if it said like disclose experiencing thoughts of harming, like I don't know, their sibling or whatever it is, like a specific sibling, then it's like you have an identifiable person that
Okay,
if
let's
I
say we have that
then yes.
because it seems like what we're wrestling with is they have told us they do not intend to act on these thoughts.
Correct.
So when
Mm,
we consider our views of Tarasoff and implementation of Tarasoff, does does our reporting requirement include just thoughts of harming versus intent to harm?
oh yeah. It's the intent to act or to harm, not thoughts.
So Noah, what do you
Wording.
got?
I think it could be B because essentially, like kind of what everybody's saying, the psychologists, they do have the duty to protect. However, simply just having the thoughts of harming someone, it doesn't automatically warrant breaking confidentiality because there has to be a serious threat of harm. Because I'm thinking about Tarasoff as well. Since essentially in this situation, the client's insisting that they have no intent to act, the psychologist still has to assess the risk.
Yeah.
I would probably think it's probably would just go on the safe assumption, just encourage the client to voluntarily to seek the help. But I think I'm kind of like debating between B and D too.
Mhm.
What is it about D?
So D, I think it could be. I think it could possibly be D. I mean, but just because it doesn't really emphasize assessing the risk or encouraging voluntary intervention first. I mean, if the client's already discussing the thoughts, I mean, the psychologist still has to assess and intervene.
It, for me with D, I think now hearing Dr. C's like the intent versus like the thoughts, like how D says like further discussion of harmful thoughts will result in breaking confidentiality. I
Why
think
is
that's
that?
because of the fact that like if they're having thoughts, it's not considered like a breach. But if
Uh-huh.
they're going to like, I have the intent to act on these, then I feel like if it's a discussion of harmful intention versus harmful thoughts will result would make it different, but it's still talking about the harmful thoughts, not a potential intent instead. So I think I would agree with Noah about B, the answer about B, like discussing, like further assessing.
So does
And
anybody want C?
no.
Well, what I don't understand about B is encouraging them to seek help. I thought the person was in therapy with the psychologist.
Exactly. They're getting help already.
Voluntarily.
And D implies we're not going to talk about certain things because if you talk about this, I'm going to report you.
Right.
Even though our client has said they have no intent to harm. Now, to your point, Natalie, we do have to, or somebody's point, we do have to assess, it may have been Noah,
Mhm.
assess their veracity, but we don't add information to these test questions. Our client has said they have no intent to act on these thoughts. They're just having these homicidal feelings. And with that said, that doesn't feel like we need to do C. Doesn't feel like we've got to report right now. There's been no threat made. Um,
And we could take out A.
why?
Um, I don't think we can continue therapy without um, at least addressing the thoughts of harm.
Without
But
reporting thoughts of harm. So it's
it's
saying continue therapy without breaching confidentiality. That may be the right answer, dude.
But they're not really addressing what's really going on. You know, you're just kind of continuing and just
You
ignoring
know the right
the,
answer, Sammy?
yeah, kind of, yes.
Okay, so it sounds like you're directing us towards something.
Okay, I like this question since there's a lot of different opinions. Let's see what the answer is actually B. And the reason is that in situations where there is potential risk of harm, the psychologist must weigh the ethical dilemma carefully. Discussing the situation openly with the client, exploring the risk, and strongly encouraging them to seek additional help through a crisis intervention team or a psychiatrist. So that brings to the point with what you mentioned, Dr. Ben. The extra help that they're seeking can be other than just their own therapist. So it could be a psychiatrist, crisis intervention. Allows the therapist might need to allows the psychologist to respect the client's autonomy while still prioritizing safety. If the client refuses to seek help, the therapist may need to break confidentiality to protect others, but first discussing it with the client is ethically prudent. Does that make sense?
Uh,
No,
I
I
I
would
disagree.
consider that a great overreaction. Thoughts
Yep,
of doing harm to other people is extremely common.
yep.
I've been in this exact situation probably 100 times, and I would continue the therapy. I would explore the feelings of violence and thoughts of violence, but I would not make a report on this basis.
And it sounds like the emphasis here, I agree with you, John. Uh, it sounds like the emphasis here is to let the client know, discuss with the client. You know, we're there's a potential chance that if you were to increase your threat level, if you were to say, you know, Uncle Bob, I'm going to go hurt him, I have to warn Uncle, I might review that with them. But it sounds to me like you're just having these thoughts and you're comfortable that you're not going to make any harm to Uncle Bob. Now, I might say something like that just to remind them there is a reporting requirement I have if this escalates. Um, but it just it to say, you know, you need to go seek other help seems much more of a cover your butt thing than an actual thing you do in therapy.
Hmm. I can see that. Yeah.
Well, the way we cover ourselves is to well, first of all, learn how to assess risk of violence.
Yes.
If it's something that you don't know much about, I would encourage you to learn how to assess risk of violence. And secondly, documenting your reasons for your action or inaction. For example, I might write the client discussed thoughts of harm against so and so, and I questioned him about it, and he denied have any intent to do so. Something of that nature.
Yeah. So documentation is always important, and knowing how to look for violent intent, uh, what you might ask. So this this the test givers rule the day, so they get to decide what's right here. So in this particular case, uh, the the answer is discuss it with them, which often in ethical questions, that's the first thing you do is discuss it with your client. But this whole referral thing to another expert is something to John's point of, you mean to tell me, Dr. Venn, that the client made these thoughts apparent and you didn't do anything. Um, or you didn't refer them, or you didn't get extra help on this. Uh, so I could see John's rule of thumb operating here, that this is probably the most conservative without harming the client. Stopping therapy is harming the client. Uh, Reporting immediately without any intent is harming the client and ending therapy. So two of these questions I think could be thrown away. Two of the answers could be discarded up front. So it becomes a matter between A and B. Anyway, I think we beat this one into the ground.
Okay. All right. I think we have talked about this before, but let's just see. So, of the following, which is responsible for the largest population of complaints filed with the APA's Ethics Committee? Is it A, sexual misconduct, B, test misuse, C, breach of confidentiality, or D, discrimination?
I know A and C often compete for this, but I'm going to say C.
C. Okay.
I think it's C as well.
Okay. Any other thoughts?
It's to me pretty damn amazing how much complaints are around sexual misconduct after so much time and effort spent on that in our stuff, in everything you read, every class you take. It just tells me that a lot of people are doing therapy not with their adult. Anyway,
Mm-hmm.
I'm gonna say A, just because of the fact that it's very heavily emphasized, and the fact that it's still emphasized till this day leads me to think that this still is a big issue.
I'm going to
Okay.
say A as well.
Okay. So the correct answer is actually A.
okay.
It is sexual misconduct. I know this justification is from a 2009 report, so I went in and searched as of 2025, and it is still indeed sexual misconduct has been um, the most reported as of today. Um,
Yep.
not, I guess there's just been many files reported against psychologists who, like you said, Dr. C, are probably not um, acting with their adults. So, um, and it's not to say that the other things do not come up; they definitely do, but it's just been very consistent with sexual misconduct.
Were you able to see the actual numbers? Because I know the numbers between sexual misconduct and confidentiality are pretty close, but it still blows my mind that the sexual misconduct is up there number one or two, no matter what we do as supervisors. Um,
Uh-huh.
and that is why I think it's so damn important for you guys to be doing your own parts work, because it's not going to be your adult who decides to fool around with your client. It's going to be some
Hmm.
other part of you that needs something. So
Yeah.
self-awareness and doing your own parts work is vital to not falling into this thing.
Hmm. Yeah, this was kind of like a shock for me as well. Okay, next question. If a psychologist acts as both a fact witness for the plaintiff and an expert witness for the court in a criminal trial, she has acted A, unethically by accepting dual roles, B, ethically, as long as she did not have a prior relationship with the plaintiff, C, ethically, as long as she clarifies her roles with all parties, D, ethically, as long as she obtains a waiver from the court.
Gosh, I think this is a John question.
And I actually did bring this question for John.
Well, I think it's misworded. You have a plaintiff in a civil trial. In a criminal trial, you have a defendant.
Ah,
Mm,
right off the bat, it's misworded. Great.
mm. Thank you for pointing that out, actually.
So I'm going to have to rewrite it. If a psychologist asks both as a fact witness for the defendant and an expert witness for the court. Okay, I'm trying to get my mind around this. When would a person be a fact witness for a defendant? Well, maybe the defendant is your neighbor and you know he's a good guy, so you're testifying as a character witness. Or maybe the defendant is a patient and you're testifying for him as being a good guy. You know he's a good guy working on his personal problems. Uh, no, that would be expert testimony. Trying to figure out when a psychologist would be a fact witness for a defendant.
A fact witness might be, he's a client of mine. I've seen him 15 times over the course of these 3 years. That's facts. And it might be called to show that he's been doing therapy.
Yes, without offering an opinion. Okay.
So I guess the crux of this for me, and I may be totally wrong, is can a psychologist be both a uh, can act as a fact witness for a client and at the same time as the expert witness for the court? Uh, I don't know that there's any regulatory stuff around this. They're asking it ethically. I'm going to just take a wild ass guess and say C, as long as she clarifies her roles with all the parties involved, with the court, with the client, and all that. Uh, I would say that would be ethical, but I could be absolutely wrong. We have two other hands up, Natalie.
I have a clarifying question about like fact witness compared to like expert witness. Like for psychologists that do assessments, for example, and have to go on the stand to like, I guess, if they did an assessment with a client, would that be considered a fact or an expert? I'm just trying to think if that could be a dual thing or if that's one or the
I'm
other,
guessing that is uh,
like an
it
evaluation of it.
depends. If the person's being called in to say, what were the results of the test?
Mm-hmm.
Versus, in your opinion, doctor, uh, what does this say about this client's uh, potential to do harm? So it becomes, are you asking the opinion of an expert on what all this means? Are
Mm-hmm.
you asking the expert, or are you asking somebody, what were the facts? Those are the two distinctions.
Okay. Because I was just thinking like with assessments, like you're stating the facts, but you're also giving your overall impression of like based off
That,
of
that,
these.
that would be acting as an expert. And if you're not an expert or you are not there as an expert, some opposing counsel is going to stand up and say, acting as an expert witness,
Okay.
object based on that.
Okay. Thank you for the clarification.
I, John, I hope I'm not just out to lunch on these opinions.
I'm guessing A, because I'm having trouble imagining any situation where this would be
That
acceptable.
would actually happen. Yeah. Because it's not like the court doesn't have options on approving an expert witness, and I can't imagine a judge being okay with this. But yeah, anybody else? Now I know, Anessa, you had your hand up. It's no longer up.
Yeah, I guess my comment was, what would the court systems? I don't think the court systems would be okay with this. They would definitely have something to say about this.
Okay, so let's take a look what the answer is. So it's actually C.
Woohoo! Being right is very important to me.
And these are the justification. So accepting multiple roles may be acceptable as long as the certain conditions are met. As long as the psychologist clarifies the nature of the multiple relationships with all involved parties, and it has the ethics code. In addition, the specialty guidelines for forensic psychologists states that acting as a consultant for one party and a fact witness for another may be acceptable as long as the psychologist clarifies his or her roles with both parties and acts in a way that does not compromise his or her judgment and objectivity.
There you go.
So
That
would an expert witness be considered as a consult based off of this explanation? Because it says acting as a consult from party and a fact witness for another. So in this case, is the expert witness a consult?
apparently.
Okay.
Remember, this is for forensic psychologists.
Okay.
John, what were you going to say?
Well, the question was testifying as an expert for the court, which I would think would be appointed by the judge.
Yep.
For example, in child custody cases, not so much in criminal cases, but in child custody cases, you get witnesses appointed by the judge who are expected to be fair to both parties. But this says, okay, specialty guidelines for forensic psychologists, which is a document it would be good for people to be familiar with if they're going to do this kind of work, states that acting as a consultant for one party. See, the question said for the court, but the answer says for one party, means you're on one side. Whereas the question was about an expert appointed by the court, which I would assume would mean appointed by the judge and not by either one side or the other.
What a mess. You know, big picture, pulling out to 30,000 feet. The idea of multiple roles, of dual relationships, is not specifically outlawed by anybody's ethical rules. They are allowed under certain circumstances, and they tried to point them out here, that as long as everybody knows what's going on and the psychologist informs everybody and can maintain judgment and objectivity, you can have dual roles. It's just hard for me to imagine this actually happening. In other words, it's not technically unethical or against the ethical rules, but you know, this psychologist isn't the only game in town. So why have one person play both roles, potentially compromising their client when they are being a expert witness? Yeah, I just don't see it unless this were a small little town that didn't have any telecommunications capability. I don't see this actually happening.
Okay,
Let's move on.
next question. So you're a psychologist treating a 20-year-old college student for symptoms of depression. The student is covered by her parents' health insurance and has given you permission to speak only with the insurance company. The student's mother calls you to inquire about her child's progress in treatment. What should you do? A, provide supportive therapy to the mother and schedule a family therapy session. B, deny that you are meeting with the student for therapy and hang up. C, confirm that you are seeing the student but refuse to share any information about your sessions. D, neither confirm nor deny that you are seeing the student for treatment.
B, neither confirm or deny. Just because of
So
Okay.
let's look at the ones we can throw out. Test taking
B.
strategy. Which ones can we throw out?
I throw out B. Because
I'd throw out B as well. Vanessa,
Mhm.
did you want to answer my question or did you have an opinion?
I have a question for clarification. Somebody please educate me on this. If this situation was to occur, does the parent or the primary holder of the insurance not know what services are being billed on their insurance
They
and
probably
by
do.
whom?
They probably have uh, a service code and a diagnosis.
Okay, so okay,
What are
like
the basic facts here? 20-year-old, is that an adult?
yes.
No, I mean, yes.
So the 20-year-old is an adult, at least in California. Adult uh, as far as being older than 18. Um, so we are dealing with confidentiality here, and the question is, how harsh are we going to be to mom who already knows she's paying for it? So we can't assume mom doesn't know. Uh, and our student has given us permission to talk only the insurance company. Interesting. So do we, the question now becomes, do we even acknowledge that they are our client or not, even though the potential is that the parents will have access to the insurance information?
That's
Vanessa.
kind of yeah, that's kind of where my question is. If the parent already knows that their insurance is paying for services, right? It wouldn't make sense for the therapist to lie and say, no, I'm not seeing your kid when clearly, parent can see, well, I don't know if that, I guess that's where my question is, how much access, how much information does the insurance company give to the primary holder of the insurance policy in terms of what's happening with their policy and how the money is being used and what services are being accounted for?
Well, if we simplify this and just make it, if a third party ever calls you and says anything about getting information regarding a one of your clients, D is the answer. I can neither confirm nor deny I have this person, and I cannot release any information. If I were to have such a client, I cannot release that information until that client gives me permission to do so. So D would be the proper answer normally for any third party calling about information regarding our clients. They're trying to complicate it with this. There's an insurance company in between that the parents uh, are associated with that may or may not, we don't know, may or may not communicate on their bill a service code or a diagnosis. Natalie, do you have an opinion?
yeah, because I was just thinking, like, I also agree with D, like, neither confirm nor deny, which essentially you're not lying to the mom about whether or not you're seeing, you're just saying, can't confirm that or deny that essentially. But also, I guess with like insurance company, like, she wants to inquire her child's progress in treatment. And if there's no like ROI on file for like to have access to any of that or be able to disclose any of that, but I feel like that's what would lead me to D. And also, I guess with insurance, I guess to the extent of what the mother's trying to inquire about her treatment other than a diagnosis. Like, do you want to know like what we're doing like stuff like that, you know what I mean? Because I don't think
Well,
insurance companies will tell you your notes. You know what I
no,
That's I
they
guess
not
why.
unless they're doing an audit. So it looks like it's coming down to C or D. Does anybody want to choose A?
No, because then that's a
No.
breach.
Because then you're acknowledging and you're inviting her into therapy
Yeah.
and scheduling family sessions when my client has made it clear he doesn't want any information released except for to the insurance company. So it does come down to C or D, I think. Anybody want to argue with me?
I would still rule out C because then you're confirming which is the breach. Like you're confirming that you're seeing the student, even though you're not going to share anything about it. Like you're still confirming, like,
The
yes, I am
safest answer is D, I think.
Mhm.
correct. I would agree.
The more
I
practical one that probably a lot of us would use if we knew mom was involved. Mom brought him in, perhaps. Mom came in to sign the documents. And in other words, if we knew that mom actually had knowledge that they were doing therapy, C would be the answer. We don't have that information. We just have the information that they're using the insurance from their parents. So D probably is the safest answer.
Mhm.
And
So I've know this because you've mentioned this multiple times before, Dr. C, in our previous conversations about ethics and about situations like this. Neither confirm nor deny is always the safest option. Um, I think this question tries to trick you by bringing in that health insurance stuff, but that's why the best answer would be neither confirm nor deny because like Natalie said as well, we don't want to confirm that this person is our patient, even though there hasn't been any ROI signed or anything to that
yep.
nature. Um, so the best answer would probably, or the safest answer.
That is probably the most protective of our client and
Mhm,
therefore probably ethically the best choice.
mhm. Because at the same time, you're also responding to the mom. You're not just ignoring her
Yeah, or hanging up on her. Yeah.
or hanging up. Yeah, exactly. Okay. So a psychologist realizes that one of her therapy client is a co-owner of the company that just hired her as a consultant. To be consistent with ethical requirements, the psychologist should A, remedy the situation in a way that the client's best interests into account, continue in both roles but discuss any problems when they occur. C, terminate her role of therapist or consultant. D, terminate her role of consultant.
That's nice and juicy. Who has an opinion?
Well, the problem that I would foresee would be the partner or co-owner. Uh, so you're consulting to this company, and let's say you offer some kind of opinion that helps your client and hurts the client's partner. You could face an accusation that you're playing favorites
Yep.
and that your relationship, your therapy relationship with one of the owners is the source of the problem.
So we're dealing with dual relationships here, multiple relationships, and one could affect the other. Our role as a psychologist is to protect, as sacrosanct, our relationship with our clients first. Now, uh, in general, if I can reasonably foresee a problem caused by my dual relationship, I should take steps to not have that dual relationship. So I could see terminating her role as a consultant as being probably the best thing for her client for potential conflicts in the dual role. Noah, what's your opinion?
I was gonna say, yeah, dual relationships is what I was thinking about too, but I'm also thinking about that therapeutic relationship, maybe compromise. So I'm thinking it could be C. But I do think that maybe terminating that consulting role could be an option if therapy is the priority.
Well, she has an established relationship with her client, and that relationship needs to be protected. So I guess I'm leaning towards D. I could be wrong. A seems to be, let's all just play nice and be good and everything will be okay. A might be the answer, but D sounds to be the most conservative for my client. Natalie.
I would throw out B because continuing in both roles is not, I don't think that would go down in the best fashion just because there is a duel. So it's for me like one or the other. I would think A or D because of the fact that if you just got hired as a consultant, like you could like always get another consulting job if like again that dual relationship if that has any effect. Like with Noah also saying like with the therapist if that takes precedence, like
But A is so juicy. Remedy the situation so that everybody's okay. That's
exactly.
really
That's
I'm
juicy.
curious. I'm curious. What is it? What do they mean by remedy the situation?
That's
if
a
you
good
have
question. In other words, act in a way that's in our client's best interest, which means the first thing I should do is talk with my client. Here's the issue. Here's what I'm afraid of.
Mm,
So
then
the
maybe it is
first thing
A.
I do in a lot of these ethical situations is you got to talk to your client.
Mm.
So A may be the answer because we don't know what's best, the best interest is for the client because we don't know the issues that the psychologist is dealing with as the consultant versus as uh, as a as a client or as a therapist for the client. So A is just seems so juicy to me.
hmm
Now that you kind of explained remedy this situation, I feel like it could be A too, because you're always supposed to have that upfront discussion and you're supposed to act in the best interest of your client, like
Uh-huh.
ethically, no matter what.
A
And
is correct. I mean, there's nothing you can argue with about this. Is
It's
talk with your
A.
client and act in their best interest. So,
Uh, yeah, it talks about how the guidelines are somewhat ambiguous with regard to this issue. But the standard 3.05 states that within a multiple relationship occurs, the psychologist takes reasonable steps to resolve it with due regard for the best interest of the affected person and maximal compliance with the ethics code. So again, like kind of discussing it with
that's
that
a lot
person.
of gobbledygook, but basically best interest of the client.
hmm mm Yeah. Do
This
we
is,
want to keep going? I notice it's 11:28.
oh, yeah, I think we're done.
Okay.
That was fun. Um, so next week, who's doing next week? Does anybody remember?
I am.
Okay, good.
Dr.
Um,
C, I am supposed to be leading next week, or at least being the leader next week on Tuesday. I will not be in session that day.
okay.
Um, yeah.
So Sammy, you want to lead next week?
Yeah, I can lead next week.
Okay, you do it so well.
Thank you,
Thank you.
Sammy.
No problem.
All right, guys. Remember, tomorrow's supervision is online on Zoom, my personal Zoom room. And Thursday group we're not going to have.
Also, Dr. C, you're still recording.
Good point. I will edit this out.